Give this. All right. Hi, everyone. Hopefully you can see me and Tricia, and you can see the screen. Just giving Tricia control. So thank you, everyone, for joining us for today's webinar, Ask Tricia, and She Answers. My name's Beth Cohen-King, and I'm the Marketing Director at Margolis Bloom and D'Agostino. To give a little context, we decided to do this webinar as we recently changed the firm name to include Tricia D'Agostino. So now it's officially Margolis Bloom and D'Agostino, or MBD for short. So I think we all believe that it's very important to have a great relationship with your attorney, and we wanted to give you access to what I think personally is one of the best people in the business, someone who really encapsulates our core values, which are listening, compassion, positivity, practicality, and someone who is always learning. So thanks, Tricia, for agreeing to do this today. And thank you to everyone who submitted questions. You'll see there's a big range, some more detailed than others. And for those who submitted yesterday, we weren't able to include them in the presentation, but given if we have enough time, Tricia will do our best to answer it. And we have broken the questions into categories, so long-term care planning, mass health planning, traditional estate planning, etc. So there is a question panel, so I know there will be questions that come up, but just be cognizant. We've really done our best to compile all the questions. There were a lot, and we do recognize that everyone has unique situations that can be highly specific. So if we don't have time to address that, that's why. And if for some reason you do need to jump off, we're recording the presentation. And with that, I will let Tricia take it away. Make sure
Thanks,
that
Beth. Can you hear me?
You have access. Is it working?
Oh, let's see. A test.
Nope. All right, let me try again. Thanks, everyone. Okay. All right, try now. Yep.
Oh, there we go. All right, oops, skipping ahead. Thanks, Beth, and thanks everyone who submitted questions ahead of time. So I'll do my best to answer them. And as Beth said, there's a question section in the webinar. So if you just type your questions in there, we'll do the best we can to get to any more at the end. All right, so the first group we have here are estate planning questions. And the first question is, if you're married in Massachusetts and you're a couple and you have separate RLTs, which I think are revocable living trusts, that contain necessary language to utilize the first spouse's estate tax exemption on the second spouse's death, what's the maximum amount that can be excluded without incurring an estate tax upon the second spouse's estate? So this question, I think, is getting towards how to minimize Massachusetts estate taxes. So in Massachusetts, under the current law, we have a $1 million exclusion. And if you use revocable living trusts, where you properly fund each trust with up to $1 million, you can pass essentially $2 million estate tax free instead of $1 when you have a married couple. Federally, that exemption is about $12 million. And that could change in Massachusetts. There is some pending. The governor just proposed some legislation to make a change to increase it to $2 million without going through utilizing these trusts. So we'll see what happens there. But for the moment, it's $1 million each person. And what you're doing is you're essentially making sure that each spouse utilizes the $1 million exemption instead of just utilizes the marital deduction. All right, next we have, oops, sorry. I'm still getting used to the mouse here. If I have accounts labeled TOD and POD with beneficiaries listed, are these monies still part of my estate upon my death? So the answer is, in terms of being part of your estate, so part of your gross estate for Massachusetts and federal estate tax purposes, yes, it's your asset. And it will be included in your estate for tax purposes, but it will not be part of your probate estate. So what probate is if you have assets that are in your name alone that don't have a beneficiary listed, someone has to either file the will if there is one, or file a petition just for appointment of a personal representative and go through the court process to actually probate that will, notify the interested parties, file publication, provide return of service, and then ultimately the judge issues a decree to appoint the personal representative and potentially allow a will if there is one. And so people try to avoid that process because it takes time and it costs money. There's a delay. So what people try to do is avoid probate by naming beneficiaries, which you do if you have a TOD, which is transfer on death, or POD, which is pay on death. What happens in those instances is typically you would provide the death certificate to the financial institution, and then the institution would pay out to the beneficiary without having to go through that probate process where you have to get the will out and so on. All right, the next one is I'm 65, I'm in good health, and I'm not married right now. I own a townhouse, a commercial building with a restaurant operating out of it. There's some cash in bank accounts and no real retirement plans or savings except for a small pension and Social Security benefits. I have a will with a friend as a beneficiary. So what do I do as far as estate planning goes? So that's the first question. In terms of estate planning, the will say who the beneficiary will be, will certainly get it to that person, but you might have to go through that probate process that I just talked about because these assets, they're in the person's name alone and with no beneficiary listed because you can't put a beneficiary necessarily on a deed or something like that. So it's likely just in this person's name alone. So in terms of estate planning, the will get it to the beneficiary, but it will probably go through probate. You could use a trust instead, like a revocable living trust, where you put the deed to the commercial property into the trust. Make sure you have beneficiaries listed on any other assets that you have, and that could be the friend. And then when the person passes away, instead of having to go through probate, the trustee can just step in and get the assets to the beneficiary instead of going through the probate. What if I get married? Can I split the will so my wife gets some and my friend gets some? And you can do that. But you probably, if you are doing this in contemplation of marriage, it wouldn't be a bad idea to get a prenuptial agreement executed with a family law attorney just to clarify the interests, because a spouse does have a right to an elective share in Massachusetts. So if they are in agreement with the terms of a will, or would be better off under the elective share than they would have been under the provisions of the will, they might file for elective share to do away with the will and get the statutory allotment. So you might want to make clear what your intentions are there. And then how do I make sure that somebody take over the business? In terms of the business succession planning, we don't actually do a lot of that at our firm, but you could leave it to somebody in the trust. You just want to make sure they're able to take it over and want to. And then there may be some more complicated issues there around business succession planning, corporate law, things like that, where you might want to bring in another attorney to help advise on that piece. And then the building has an SBA loan on it. So will they honor my heirs as owners when I'm gone? That's again something that you want to look at those loan documents and talk to them about. That would be part of the succession planning. And in terms of the loan, before you transfer the property into a trust, you'd also want to make sure that you can do that under the terms of the loan without an issue. When you have a mortgage on a primary residence, for example, and you want to put a primary residence into a revocable trust to avoid probate, you can do that because there's a federal law. Well, let me back up and say that typically when you sign a mortgage, there's a clause in there that says if you transfer it to anyone without notifying the mortgage company, then the mortgage company can call the whole loan due. But there are some exceptions, and when you're transferring property to a revocable trust just for estate planning purposes, for example, is one exception where they can't call the whole note due. And I don't know if that same exception applies to SBA loans with the business, but you'd want to check that before you did any transferring there. Okay, so the next one, next section is long-term care planning. And we have the first one, for a healthy adult with no major health concerns, is there an ideal age when a long-term care plan should be purchased? So I think this is asking about when to purchase long-term care insurance. We actually don't sell long-term care insurance or do a lot of work with it. We deal with helping people when they don't have long-term care insurance and they're trying to get coverage by Medicaid or also known as Mass Health. But what I've heard from other financial planners that I work with and long-term care insurance agents that I know, typically people start to look at this in their 50s, mid 50s, early 60s, because the later you purchase it, the more expensive it is. The earlier you purchase it, the longer you pay for it. But definitely something to consult with your financial planner about. Again, this one I left on here, but it's really a question for your financial planner. This one is, what are features to keep out for when shopping for plans, long-term care insurance plans? Both things you want and things you don't want. So you should definitely talk to your financial planner if you have one. There are also folks who specialize in long-term care insurance, and we have a lot of trusted advisors that we know. If you need a referral, please feel free to reach out to Beth or myself by email. And we can get you some names of people that you could trust. I understand that Mass General law, if your long-term care insurance coverage is at least $125 a day, along with other coverage, Medicare will not consider your home as a countable asset. Massachusetts is the only state that has this exemption. My question is, all of this true? So, just to back up and give some of you some of the background here. So it's actually Medicaid, not Medicare, which a lot of people get those two mixed up. Medicare is the federal program that helps with hospital stays, insurance, something that we're all paying into and will have. It's not a means tested benefit, it's an health insurance. It also doesn't really pay for any long-term care. So typically, Medicare will pay for up to 100 days of coverage in a skilled nursing facility if you are discharged for rehab, but they don't cover long-term care going forward. Like, they're not going to pick up the cost of home care or cost of care and assisted living. Medicaid, which is a federal program and we call Mass Health here, is the program where we are looking to see if we can get someone eligible to pay for those things, just like the long-term care in the home or nursing home care or assisted living. That's Medicaid. And there is an exception. And so in order to be eligible for Medicaid, you can only have, a single person can have $2,000 in countable assets plus one primary residence, and a couple can have about $137,000 plus a primary residence. And what happens is the agency, even though they let you keep a primary residence, they'll put a lien on it for the value of services that they pay on your behalf. And then when you pass away or when you sell it, they try to be repaid for whatever they've paid for you. So that's what this question is getting to. There's an exception in the regulation that says if you have long-term care insurance that meets certain minimums, and the minimums are that it covers at least $125 a day, and that there's at least, I believe it's either 730 days of coverage total or 760 days of coverage, then the agency will not put a lien on your property or seek to recover from your estate. So it's a way of avoiding a Medicaid lien or estate recovery, essentially. So that is true. And I don't know if Massachusetts is the only state that has that exemption, but we are one of the only, I believe. It's definitely unique, and it's a great regulation in the sense that the agency is trying to help people that have gone out and tried to purchase long-term care insurance to take care of their long-term care and to protect their assets. But there are some issues when you go to use it, in the sense that you do still need to have some days of coverage on that long-term care insurance policy when you go to use it. So you can't use it all up in an assisted living, move to a nursing home, apply for Mass Health, and then seek the safety of your long-term care insurance policy because it's no longer in existence. So just something to keep in mind there. This is another one I would just defer to your financial planner. This is someone looking for good companies offering long-term care insurance because a lot of companies are getting out of the field. So again, something to talk to the financial person about. I bought long-term health care, but what if my expenses exceed the amount supplied? Should I then consider Medicaid? So this is another question about long-term care insurance. So typically you buy a policy, there's all different ranges of coverage, and this person's saying, what if I didn't get enough, which is often the case. It doesn't usually cover everything. So you can apply for Medicaid or Mass Health if you're otherwise eligible for it to cover the costs that long-term care insurance do not. All right, so next is, what are best options for incapacity care planning if one does not qualify for long-term care insurance, has assets that wouldn't fund more than 3 years at a skilled nursing facility, and a lifetime fixed income within 70% of the AMI? So in this case, if someone doesn't qualify for long-term care insurance and doesn't have unlimited funds, typically what happens is, and then the next question, which is how can they access quality of life cash beyond $73 Medicaid allowance? So what happens is, say someone comes into us and has, as this person saying, a couple $100,000, they don't have long-term care insurance, and when you go on Mass Health, you're only entitled to keep $73 a month for your personal needs, so for things that you need beyond what the agency covers. And just to back up and tell you, what does the agency cover? If you're in a nursing home, you typically pay some portion or all of your income to the nursing home every month, and Medicaid/Mass Health pays the rest. So it's pretty comprehensive. But there are other needs, personal needs that the individual might have. At the moment, what we would probably recommend is for the person to create a disability trust. So there are pooled disability trusts that folks who are over 65 can contribute their money to, and then the money is there for their benefit for their lifetime. And they're also immediately eligible for Medicaid because it's a permissible transfer. So there's no 5-year look back for putting money into a pooled trust. You can do it and apply for the nursing home right away. The agency does require that Commonwealth of Massachusetts is the first name beneficiary on the pooled trust. So when the person passes away, the state will get repaid out of that trust for whatever they've paid for that individual, to the extent there's money left in it. So it is a way to put money aside to allow money to be there up over and above the $73 a month for the individual for their lifetime, and then to say, okay, well, we'll pay the state back if there's anything left after. So that's probably what I would do in this case. And then another part of this question is, which is more attractive to a skilled nursing facility or a continuing care facility, and does it make a difference which? A prospective resident with 80% of lifetime income and 200,000 of assets, or an applicant with 65% of income and 500K of assets? I don't know the answer to that. I don't know how the facilities make that assessment. I think for a continuing care facility, for those of you who don't know, those are places where there's typically different levels of care. So independent living, assisted living, nursing home, and you pay a chunk of money up front, like a down payment, as if you were buying a home. And then you move in and you pay a monthly fee based on your independent living. That fee would go up if you move to assisted living and would go up if you move to skilled nursing. So depending on that location, the amount that they require you to have to put down varies. I've seen anything from 200,000 to 600,000. So it really just depends. And what I would say is, if you're trying to figure this out, there are people, social workers that you can hire to help you. They're called aging life care professionals. They are former social workers or nurses typically, they know the ins and outs and all these different facilities and what they're looking for, and they can help you find the right community for you. So I think you could find them. They have a trade association. It's called Aging Life Care Association, and this one, it's either called Massachusetts ALCA, ALCA, or New England ALCA. So if you look that up, that would be a good place to find some folks to help you there. And then the last question is, if no heirs to preserve assets for, can you avoid probate by naming heirs on a retirement account and bank accounts? So the answer is yes. You can avoid probate by making sure you have a beneficiary designation. Not all bank accounts will allow for a beneficiary designation option. That's when we usually use trusts, but you could check with the institution to find out if they have like the POD or TOD option, as we learned about in the first question. And can named heir be appointed to distribute the funds according to the will? So if you have a will, you can name the same person as the personal representative. That used to be called the executor. That's the person who's going to manage the process. That person can be the same as a beneficiary. I think that's what that question is getting at. All right, next is there a calculator that can help with estimating long-term care costs? If not, what are some reasonable assumptions to make about days, years spent at each level of care, assuming staying at home for as long as possible, and if needed, moving to a memory care facility? How does your company calculate these costs and what assumptions are made? What type of investments are most appropriate to fund the long-term care needs? How does someone find a reliable licensed fiduciary to handle one's financials if they will be in need of that? And is there a calculator available to investors that calculate how much money to move to a Roth without moving to a higher bracket? So I left this on, even though this one is definitely one for your financial advisor. I wish I had some of the people on here that I use as trusted financial advisors, because they would definitely be able to answer this better than me. And I've seen some of the work that they have done where they have programs that they put all these different goals into along with your assets, and they kind of generate long range plans to show you how this would all kind of project for you based on your specific needs. So if you don't have a financial planner that you trust, definitely reach out. We'll get you some names of folks. But these questions are primarily for that person, not for us. What I can answer is the third question, which is how to find a reliable licensed fiduciary, not a bank or another institution, to handle the financials if they're in need of that. So that comes up for us here and there. Oftentimes, so the fiduciary is going to be your power of attorney, the person who's going to pay your bills if you can't, or your trustee, going to manage your finances if you need help, or upon your passing, or for your children after you pass away if you want a continuing trust. We do serve in those roles. The attorneys in our office will do that. So sometimes a lawyer can do it if you don't want a bank like naming Cambridge Trust Company outright or something like that. You could find an attorney that you want to work with. You just want to make sure that you have a good relationship, obviously, and that they are well educated and understand what your wishes would be in various situations. The next is the Secure Act, although I just want to check to make sure I didn't skip one because I thought there was another one there. I think I did, sorry. Nope, I guess I did. Okay, sorry about that. So next is Secure Act. So the Secure Act, just so to give you some background for anyone who doesn't know what that is, in 2019, that was a federal law that passed that changed the way you managed inherited IRAs and 401ks. So prior to the Secure Act, if I were to inherit an IRA or a 401k from my parents, I would have to withdraw it over my life expectancy. So you have to start taking minimum required distributions and paying income tax on those distributions each year. In 2019, the Secure Act changed that to say everybody who inherits an IRA or 401k has to withdraw it over 10 years instead of over their life expectancy, unless they are certain eligible designated beneficiaries, which are a surviving spouse or a disabled beneficiary, chronically ill beneficiary, or a trust for a disabled beneficiary, or a minor. So for all of those people, they actually still get to use their life expectancy to withdraw the account, so they can defer that income tax longer. And then when a minor turns 18, they have to get it out within 10 years from that, so that they get the remainder of their life expectancy to age 18 plus 10 years. So that's what these questions refer to. So the first one is about the disabled and chronically ill. There are two categories of beneficiaries who can stretch the IRA distributions over time instead of 10. So what proof is required? So this is questionable because this is a pretty new law. So trying to figure out what the companies are going to require to show that somebody's disabled is not totally clear yet, because we're still doing it. I haven't done one yet where I've had a disabled beneficiary that's had to prove it, but the regulation is the definition of a disabled person under the revenue code is IRC 72M7. And it's basically, it's pretty similar to the definition of that Social Security Administration has for deeming disability, which is that basically they can't engage in any substantial gainful activity. And the difference in this one from the Social Security is that this is expected to result in death or be long and continued and indefinite in duration rather. So, and then for chronically ill, the code is IRC 7702B, and again refers to that chronic illness as being indefinite and reasonably expected to be indefinite in nature. So I think if the person is eligible for disability under Social Security Administration, so receives SSI or SSDI, that would be sufficient. It would be my assumption. And then in terms of who can make the determination, the regulation for chronically ill says it can be made by a physician, a registered nurse, or a licensed social worker. So again, I wish I had some more clarity there for you, but that's all we have so far. We just have to go on just those definitions and sort of start to use this law in practice and see what comes of it. I know that Secure Act 1.0 made a big difference in estate planning by replacing the stretch inherited IRA with a 10-year payout rule for most other than a spouse or disabled beneficiary or minor. Beyond that, can Tricia highlight other changes in federal law in the very recent past or upcoming changes that would cause a person to want to revisit a plan? I don't have anything to highlight yet. I do think that we're all just kind of watching the estate tax planning as that plays out to see what's going to happen with that. Federally, at the moment, it's 12.06 million, I believe, a person is the current exemption, and that there are proposals to change that. So I would say if that does change, we want to make sure you're revisiting your plan to make sure your trusts are properly funded. And the same would be for Massachusetts. Next is crisis planning. And this says you need to be in a place where you receive substantial care in order to continue life as comfortably as possible. A triggering event has taken place and now your spouse, children, or others have power of attorney that allows them to make all the decisions for you. Some facilities that provide around-the-clock care are really good, but rather expensive, while others are not so good and might cost less. You have substantial assets that could easily pay for the better, more expensive facility, but you are worried that the people with your power of attorney might either make poor decisions when choosing a facility to care for you, or, sad but true, they might want to preserve the assets in the estate to increase their own inheritance. What kind of steps can be taken to increase the likelihood that the available assets, your assets, are used for the purpose of taking very good care of you, not just adequate care, but very good care? So this comes down to proper estate planning and making sure that you're picking the right people to serve in those roles. So often people just assume it should be my child, one of my kids, or they're going to be the person because they're closest to me, they're my relative, but it may not be the best choice. If you have any reservations like these listed here, you could choose your attorney to be in that role who has no end game. There's no interest, no conflict of interest there. You'd want to make sure that person knows that it is your desire to use all of your money, if that's the case, to privately pay for your care, that you're not interested in trying to do Medicaid planning. If that means that you're going to get a different type of care at a different type of facility, you can put that kind of language into trust documents to say, this is my intent. So it's pretty clear to the trustee, whoever that is, that you want to spend all of the money on your care if that's the case. And then this is also a place where I would bring up that care manager again. So I had a case like this actually where this woman knew that she had this diagnosis that would likely lead to issues, long-term care and cognitive impairment issues in the future, but she was totally fine, obviously, when she found that out, and was able to hire a care manager, which are the aging life care professionals I was telling you about earlier, who she met with, and she told what her wishes would be. She trusted her very much. They developed a great relationship. So then when the client needed care, she deteriorated pretty quickly, actually, within a year or two. The care manager already had a relationship with her and knew what her wishes were. Everybody felt comfortable. Like she made a relationship with that individual before she had cognitive impairment, instead of vice versa. When if you wait till you don't have the ability to make decisions anymore, someone else, like a child or the lawyer, is going to recommend care manager, and that's who's going to make the decisions, and that person may never have had any communication with you whatsoever. So it's not a bad idea to have communications with care managers in advance of things happening as part of your estate planning. All right, so you're very ill and hospitalized, and you're no longer in a position to make informed decisions about your own care. Your family wants to get you the very best medical care possible, but they're upset and confused and very unsure about the best course of medical treatment, as is they find that not all doctors explain things well or seem all that helpful. As a result, your loved ones are not in a good position to make the best decision for you. So the question is, who can be engaged to advocate for you? Is this often done? And if not, why? If this can be done, how is it done? So this is the same, another push for care managers, but I guess with the last question, with the money part, that's going to be your lawyer or a trusted friend even. It doesn't have to be the child, but someone who doesn't have a legal interest if you're worried about making sure the money is spent on what you need, not preserved for the next generation. But a care manager too, so that it's clear what your needs, so that they know what your needs are and what your wishes are. But this one is definitely a care manager question. So care managers can not only help you locate a place or a community that might be good for you, they can also advocate for you. So if there's a medical decision that needs to be made, or there's someone trying to discharge you from a hospital and move you someplace else, those are the people that can come in and hit the ground and start advocating, right? In the hospitals, with the facilities, with the assisted livings and so on. So it is often done, as I've already mentioned it a few times here. We recommend it a lot. I would definitely take a look at that organization that I mentioned earlier, the New England ALCA, and we also know a lot of care managers if you ever need somebody in a specific area. All right, so mass health planning. I wanted to know if a discretionary testamentary trust established in a will of a deceased spouse for the benefit of a living elder spouse is exempt from Medicaid long-term care assets and the 5-year look-back period. So the answer is yes. So there is a regulation that says that if you create a trust at death, which is what this is, when you have a will with a trust in it, the trust does not get created or funded until the person dies. If you do that, and if it's for your spouse's benefit, the assets in it can be used for your spouse for whatever they need, but they are not countable for purposes of mass health. There's also no 5-year look back because it happens immediately upon when the person passes away. The assets flow through their will into the trust for the benefit of the surviving spouse, and there's no penalty, no 5-year look back. The disadvantage is that the estate does have to go through probate in order to fund that testamentary trust. The only way to get it through the will is if there's no beneficiary listed, and if it is not jointly owned or it's just in the individual's name alone. So that's the disadvantage, but there's a large advantage. We use these a lot in long-term care planning. If I needed to use Medicaid, I would need to divest myself of money. Could I place my money, securities, and business in my son's special needs trust along with my home to avoid giving the money to the government? So the answer is yes, you can transfer assets to a disabled child or to a trust for a disabled child for the sole benefit of the disabled child. And there's no 5-year look back. So what this is the 5-year look back. I've mentioned it a few times. I should just mention the big picture is if you can only have $2,000 of assets plus a primary residence for a single person, or you can have about $137,000 of assets and a primary residence for a couple. If you give assets away to get to that number, Mass Health says that you can't qualify for benefits for 5 years from doing that because of the 5-year look back, essentially. So you can't just give all your money away and then go on Medicaid, but there are some exceptions, and one is the ability to make distributions to a disabled child or a trust for a disabled child. There's no 5-year look back for that. My husband has Alzheimer's disease. Eventually he may need a placement. We've talked about protecting assets with annuities, but I just learned recently that in order to do this, a facility must be a long-term care with skilled nursing. Generally, a nursing home appears to be assisted living with a memory care unit. Is that accurate? Would you explain the requirements? So what I think this is if you have a couple, and if they have more than that $137,000 of assets, one common tool to create eligibility for the spouse that needs the long-term care is to put the assets in the healthy spouse's name, and for her to buy what's called a Mass Health immediate annuity. So in essence, you're taking the asset and converting it into income for the healthy spouse. And if you name the Commonwealth of Massachusetts as the first name beneficiary on that annuity, then and there's some other requirements under the statute as well, then the unhealthy spouse can apply for Mass Health and be eligible right away without a 5-year look back. So this is a question of, in order for that to work, does it only work for nursing homes or does it also work for assisted livings? And that's a question in terms of Mass Health coverage. So Mass Health covers almost every nursing home in the state. So you can pretty much go to any nursing home and Mass Health will pay for it if you're eligible. That is not the case for assisted livings. Mass Health does have contracts with assisted living facilities and with certain programs that provide financial assistance there in assisted living, but not everyone. So yes, you could use the annuity approach if you were trying to create eligibility for assisted living coverage, but you would want to make sure the facility has a contract. And I think that's where the issue is that there's not as many assisted livings as there are nursing homes that actually have a contract with Medicaid. My elderly parents live with us and we are trying to plan the best we can in case they ever need to move into assisted living or go into a nursing home. Since they do have a lot of assets, they would qualify for Medicaid to help with these costs. Since they do have a lot of assets, would they qualify for Medicaid to help with these costs? Sorry, it's hard, having a hard time reading on the screen. Is there any way they would go after our assets? We claim them on our taxes and we weren't sure if that complicates things. So in terms of their assets, we'd have to look and see what a lot of assets meant. I would recommend having a consultation, which is when we kind of give you a questionnaire, ask you a whole bunch of questions about the assets, how they're owned, who the beneficiaries are, and we can kind of make an assessment as to whether they qualify or what they might need to do to qualify. They won't go after your assets unless you share them. So sometimes kids are on the deed with the parents, so it's like the husband, the wife, and the daughter, her husband rather, and the daughter's mother, or something like that, or co-owners on a deed. In that case, we'd have to look to see how that deed is titled and whether there's any issue there with a potential for Mass Health to try to put a lien on that property. So, but otherwise, they're not just going to generally go after your assets because they're living with you or you claim them on your taxes. Trusts. So next is, my home and summer cottage in New Hampshire are in an irrevocable trust for my 2 daughters. I know I'm able to sell my Wayland home and buy a home elsewhere, but can I do that with the cottage in New Hampshire as well? It's a second home and maybe subject to capital gains. So yes, the second home is going to be subject to capital gains. The exclusion on the tax on capital gain is only on your primary residence if you meet the use and ownership tests. And the house in New Hampshire is in an irrevocable trust. So you can't sell it because typically, if it's a Mass Health, I'm assuming this is a Mass Health irrevocable type trust, in which case you're probably not the trustee. So the trustee of the trust could sell it likely if the provision is in there authorizing them to do that. But what happens with the proceeds is dictated by the terms of the trust. And if it's a Medicaid qualifying irrevocable trust, you're probably not entitled to any of those proceeds. So that's something to check with the lawyer that drafted this for you and ask. Also, can you get equity from a home in an irrevocable trust or take a loan against it? You can't, once the property is put into an irrevocable trust, you cannot get a loan on it. It's very difficult for a mortgage company to secure their interest in an irrevocable trust. So I have not found a company that would do that. I own a house in Woburn that I always rented out. I live in Framingham. Oh, this is, okay, I remember this one. So your daughter, this one woman's daughter is on Section 8. and her grandson's also disabled but due to a very bad accident. And so she's received some permission from Section 8 where they can rent from her, even though typically you can't get Section 8 for relatives. And the daughter and son are both on SSDI, and she wants to leave them the house when she passes away, but she doesn't want to impact their eligibility for these benefits like SSDI or Section 8. So number one, I think comes up all the time too. I think it's SSI that you're probably referring to. So SSDI is Supplemental Security Disability Income, which is basically asking for your Social Security retirement income early because you're disabled. So that's not a means tested benefit. So you can inherit anything, you can have income, you're just entitled to that, your income early in essence because of your disability. So it's not a means test. SSI is Supplemental Security Income. That's the one also distributed by the Social Security Administration. Also, you have to be disabled to receive it, but there is a means test, meaning that you can only have $2,000 in assets, and then you can also have a primary residence if you live in it. So if it's SSDI, we're not worried about them losing anything from inheriting. But if it's SSI, you are, and so you could leave it in trust for the person's benefit, a supplemental needs trust that can be drafted by an attorney, and then the assets are not countable for purposes of their benefits. And in terms of Section 8, typically assets in a trust are not countable for, a supplemental needs trust are not countable for their benefit either, although sometimes distributions from a third party supplemental needs trust can impact rent. So that would just depend, but I would definitely see a lawyer and get this situated so that the house is protected, and not only just preserving benefits, but with people with disability for management purposes too, so that there's a trustee in charge to manage it so it's not left to them if it's too much for them to handle. All right, so this one, I used to work with over 65 pool trusts. Now that that is gone, what are folks doing instead? I'd love to know, as I still work with elderly and it does come up. So this isn't gone. We still do this. There was talk of this being gone at one point, and by being gone meaning that the agency was no longer going to allow transfers to pool trusts for folks over 65 as a permissible transfer. But at the moment, those are still allowed. And I mentioned those at the beginning. That's when you can transfer assets, your own assets, into a pooled disability trust. The assets can remain there for your benefit for your lifetime, and you're immediately eligible for Mass Health. And the agency does get repaid when the person passes away, to the extent there's any money left. There's a family home in Leicester. My mom still lives in the house. My brother-in-law has taken over the mortgage payments. My mom's name, my brother-in-law's name, and my sister's name are all on the deed. When my mom passes, what will the tax consequences be, if any? And should we put the house into a trust? If so, what's the best to consider? We want to make sure that Uncle Sam won't rip the house out from under us. So in this case, there's a few things in terms of her gross estate. If she owns 1/3 of the property, that's going to be included in her gross estate for her estate taxes. But then the beneficiaries will receive a step up in basis on that 1/3, which would be helpful potentially for capital gains tax in the future. It just depends on whether she, so it depends on the size of her gross estate as to whether it generates a tax return or not. And then in terms of Mass Health, if the property is owned as joint tenants with the rights of survivorship, so what happens, she receives Mass Health and they put a lien on the property, and when she passes away, they seek to recover. They'll only recover under estate recovery if it goes through probate. So if the house is owned as joint tenants with rights of survivorship and the mom passes away, it should pass to the other two owners without any estate recovery or Mass Health recovery. If it's sold while she's alive and she's on Mass Health, there could be an issue there with her share being eligible for the Mass Health lien for the services paid on her behalf. So this one is one where I'd say check in with a lawyer, because it really depends on a lot of factors, like will she need Medicaid or not, and how does the deed read, and that sort of thing. All right, so that's that. And then I have a few other questions that came in to my email. that I can try to address. I know we're already at 12:45 here, so let's see. So one is there any way to get on the Frail Elder Waiver if you're over income? Any spend down program? So the Frail Elder Waiver is a program, Mass Health program that provides assistance to people in the community, so home care. And to be eligible, the income limit is gross income, and it's about $2,300. And once you're over that, you have this enormous deductible, the way the current law reads, and it's very difficult for people to qualify because they have to pay for expenses in the home as well. So they're trying to pay for their mortgage or rent or gas, heat, stuff like that, and trying to meet these huge deductibles doesn't make it, then they can't even take the care at home because they can't stay there safely. So they end up having to move to a nursing home. At the moment, there is some legislation pending to fix that calculation, but there isn't anything at the moment to spend down the income, other than to spend it on a deductible. When leaving your money in a will to charities and relatives, are you better off doing a lump sum and some percentages, or does it really matter? So depends on the size of the estate. We usually say percentages because we don't know how much money is going to be left when someone passes away. So if you say a fixed dollar amount and that person gets that dollar amount and the rest is to go somewhere else, then what if there isn't anything left to go there? And then the last one I'll do is the Medicaid application process. Just how long is the Mass Health application process and what does it take and entail? So if you're doing an application for Mass Health coverage of a nursing home, it can take a few months for that to go through, but you can have retroactive eligibility to 3 months from the date that you actually create the eligibility. So it is a long process. You file the application, you get an information request. There's a lot of back and forth, and those are things that we do for clients. They're time consuming. They do take a lot of time, but ultimately they will get through the process if they're done right. And the nursing home will get paid retroactively. And the other part, there's a few parts of this question. The other is if someone's running through their assets in private pay, at what level of the remaining liquid assets should they consider institutional care so that they can get into a nursing home before they apply for Mass Health and have some private pay money. And that depends on the facility. And another question, I think, for a care manager, but I've heard people say like 3 to 6 months or something like that. I've had other clients that pay no dollars of private pay and they just go right on Mass Health. So it just depends. Just depends on the situation in the nursing home and the availability. But I think I'll stop there because we're already at 10:01, which is over.
All right. Hopefully you guys can hear me. Tricia, thank you so much. I know this is a lot and it's, everyone has different questions and it's hard to sort of channel everything and try to answer everyone's question, but I'm very grateful for you taking the time to do this. Just to repeat, we will have a recording of this, so you can go back. It usually takes about a week turnaround. You'll see it on our website. If you haven't been able to check out our new website, margolesbloom.com, we redesigned the whole site along with when we changed the firm name. So there is a ton of content on there to make sure that probably answers other questions you might have too. So please be on the lookout for it. And also I will post the recording on the website too under news and events. So with that, thank you so much to everybody and hope you have a great day.
Thank you, everyone.
Hold on.